Ladies and gentlemen, welcome to our session, Lights, Camera, Lawsuit, Season 9, sponsored by Access Pro. Here is our moderator, Assistant VP Claims, Access Pro, Patrick Groshong.
Good afternoon. Very excited to be here to do the 9th installment of Lights, Cameras, Lawsuit, which we've been doing for 9 years now. Perhaps even more thrilled to have this wonderful panel here for you today. Starting at my far right is Lynn Carrillo. She is Senior Media Counsel for NBC Universal. Prior to joining NBC, she was in private practice, and before that, she was a reporter for the Miami Herald and the Sun Sentinel. To her left is Ivan Perrone. He is the principal of the Perrone Law firm, an entertainment, media, and sports law firm based here in Miami Beach. He focuses on representing producers and production companies. Prior to founding the Perrone Law firm, Ivan was in-house counsel for Universal Music Group. And to my right is my friend Chuck Tobin. He chairs the media practice team at the law firm of Holland & Knight. Chuck is based in Washington, D.C., but also practices out of the firm's Florida offices. Prior to attending law school, Chuck was also a reporter. He worked for the News Press in Fort Myers, Florida. The topic that we're going to treat, I think, is very timely, and that is when film and program content is created based on real-life events. There are a number of instances in the news right now that may or may not relate to that. One of them is, as I'm sure many of us are aware, possibly the Kennedy miniseries, where at least reports are, this was supposed to air on the History Channel, where at least reports are that the Kennedy family took some umbrage with that miniseries. In litigation right now, which that of course is not, is the Hurt Locker case. It's based on the Hurt Locker movie, where a soldier who did a similar job of bomb disposal has filed suit claiming that that film is based on him. That case is still in litigation. To help us talk about this issue, we've put together a hypothetical fact pattern that we'll walk through. And that's going to be posted on the big screen so you can refer back to it as we go through this discussion. But I'll go ahead and read it for you from the outset. And this, by the way, is based on a libel by fiction case, loosely. It seemed appropriate for this panel. A libel by fiction case that was tried in Georgia recently. You are the producer of a made-for-TV movie about a group of women who meet once a month for drinks while wearing funny hats. The screenwriter admits that the characters are based on a number of her friends, but that she embellished their backgrounds to make the movie more interesting. Two of the characters, Julie and Laura, share the names of her friends, and a third character is a composite of several. The events set forth in the movie relate to vengeance the three took on Julie's husband for philandering. I'd ask the panelists to assume that that vengeance was really very bad, criminal acts, that sort of stuff, things that you wouldn't want to see about yourself in print. The real Julie was similarly jilted, but the friends did nothing to the husband. Julie, in the film and in real life, is the mayor of a large city. Lori is a waitress and an alcoholic in real life, both of which are common knowledge. That said, she is also portrayed as having psychiatric problems in the movie, which the screenwriter included as a fictional element, but which she learned was true only after the production received the green light. The actress playing Julie, finally, is the spitting image of the real Julie, and because she is quite lovely, the production company wants to feature her in the marketing for the film. So we'll start with you, Lynn, in-house counsel. The producer has walked into your office, has plopped down in the chair opposite you, perhaps kicked his feet up, I don't know, and has said, I've got this wonderful project that's going to make me millions of dollars. Please pull that rubber stamp that I know you have somewhere in your desk out. Stamp this thing so I can go out and make a whole bunch of money. Lynn, do you see any problems with, from a legal standpoint, from a creative standpoint, there are probably a million problems with it, but from a legal standpoint, with our hypothetical?
Sure. The first thing I'm going to tell the producer is it's great if you're going to make, $1 million on this, because we're going to be paying $1 million in lawsuits over this if we're not careful. So the first thing I would do is I would sit and talk to the producer and go through and issue spot the different issues that we'd have. Okay, so that's what we'll do today. Well, the first thing is, have we gotten the rights from Julie to use her name, image, and likeness, especially if the actress is the spitting image of Julie? Have we gotten the rights to use her name, to use her life story associated with this program, which Ivan can talk about. Then we're also going to talk about defamation. I mean, we've said that these women who can be identified, both Lori and Julie, can be identified, as well as a third individual can be identified, and we are going to have potential defamation issues.
Can I jump in real quick and ask you what exactly, we've heard defamation a lot, but what actually constitutes defamation?
Defamation is damage to a person's reputation. So it means that if we are producing something or publishing something or even republishing information that could damage an individual's reputation, credibility, standing in the community, even work environment, even their reputation in the workplace, then that in and of itself could lead to a lawsuit by the individual against the production company, as well as the company who broadcasts it. Because sometimes I may have this producer in front of me, but is this producer going to be the one selling it to a broadcast company or to a station who's also going to be publishing it? So depending on who I represent, that's going to be one of the issues. Am I representing the broadcaster or only the producer? And then we can contract some issues away, but ultimately the producer is going to be responsible if there are potential defamation issues. Some of the other issues that I would see is the right of publicity. Have we intruded on individuals' right to privacy without getting the right permission, not only from the individuals, but the associated individuals? I mean, we're featuring Julie's husband here, and we're saying that he committed, adultery. That in itself is potentially defamatory. And if he did not commit it in real life, well, we have that he allegedly did. Okay, we don't know if they're divorced, we don't know what the story is, then that could also be potentially defamatory. So those are just some of the small issues that I would see.
In terms of right of privacy, I mean, how broad is that right of privacy? I mean, particularly if he's married to a public figure. I mean, isn't he kind of out there? I mean, isn't that something that's fair game you can talk about?
Not necessarily. First of all, he's not the public official. Okay. She is. So for all intents and purposes, he is a private individual. And if he committed adultery in most states in the United States, saying someone committed adultery, either male or female, is considered defamatory according to the books. Why? Because defamation law is a very old theory. So most states still have that if you're saying someone committed adultery, it is ruining their reputation in society. Keep in mind, defamation didn't come around in the 2000s or 1990s. It originated back in the early 1800s. So we're still using the same moral standards of back then in most of our state laws. And especially if you're in the South, that's going to be even worse because they have higher standards on defamation and societal standards. So it also depends on where you are, that it may be even more of a problem.
Okay. Well, you were talking about commercial misappropriation, I think.
That's another issue.
Yeah.
That's the issue on the right of publicity. Right of privacy has 4 main points. Misappropriation, which is taking someone's image or likeness and using it for your own commercial gain. That comes in if they're going to use Julie's name in the marketing materials. So if you're going to use someone's image or likeness in marketing materials, putting them on a billboard on the highway or putting them on the cover of the book, then you need the permission of that individual in order to commercially use your material and that person's image or likeness associated with your material. Okay. Then there's also trespass, which they may be being portrayed as having invaded someone's privacy because they may have trespassed or allegedly trespassed if they committed some crimes. And then we have 2 other rights of privacy which really wouldn't apply here.
Okay. Well, the right of privacy, I know, Chuck, your firm had a case that really was kind of in the wheelhouse of that, and that was the perfect storm case. I wonder if you could tell us a little bit about that.
Yeah, wheelhouse is an apt metaphor.
Yeah.
For those of you who don't remember, The Perfect Storm was a Warner Brothers film. It came out in the year 2000. It starred George Clooney as Billy Tyne and John C. Reilly as Dale Murphy. And it involved a ship a fishing boat that left port in Gloucester, Massachusetts in 1997 and sailed right into the perfect storm, a hurricane. Everybody on the ship was lost. And 3 years later, a writer named Sebastian Junger came along, and he wrote a story very closely based on what really happened, what we know really happened to the vessel, the Andrea Gale. Now, he did make up dialogue as he went along because nobody knows exactly what was said on board the ship, but it was, as we see in the credits of so many theatrical productions, it was based on a true story. Years later, when the film was a hit and a success, the family wanted a piece of the action, and they had not gotten rights clearance. They had not given the rights to the movie, and so they did what every good American who feels screwed did. They went out and they got a lawyer, and they filed litigation here in Florida. The litigation went all the way through the trial and appellate levels. My firm handled it. And it actually ended up very favorable. Warner Brothers and the producers, who were named, by the way, heads up for you all out there who are producers, the producers were named as defendants in the lawsuit. At the end of the day, it turned out okay for Warner Brothers for the simple fact that the information contained within the movie was not private. When you talk about invasion of privacy, Lynn was talking about the allegedly philandering husband who is not a public figure, and these people themselves were not public figures. In order to succeed in an invasion of privacy suit, it has to be private. And what happened on board the Andrea Gale was national news at the time. The ship was missing. The Coast Guard dispatched a vessel, you may remember from the movie, if you saw it or read the book, that a Coast Guard person died trying to rescue people on the Andrea Gale. So at the end of the day, it was not private, and so they did not succeed in their invasion of privacy action for the family. In addition to the fact that they sued on behalf of the dead fishermen themselves, and it's a cardinal rule in what I do for a living, dead people don't have privacy rights when it comes to that kind of litigation.
Mm-hmm. Okay. So I'm the producer, and I'm still sitting in your office, Lynn. And I say, look, I've read this Perfect Storm case. I know about this, all right? I'm pretty savvy. I mean, this falls in the wheelhouse of that. And oh, by the way, this is something that I hear a lot. This is based on a true story. I mean, if we say at the beginning it's based on a true story, doesn't that make it better? Or maybe if I say it's inspired by a true story, would that make you more comfortable?
Not really.
And why is that?
Because
Oh, I'm sorry.
excuse me, we haven't gotten the rights from the individual.
You haven't gotten the rights from the individual, Ivan? I mean, what's your take on that? I mean,
well, one of the fastest growing areas in litigation is rights and publicity. The reason why is because there really haven't been any acknowledged boundaries as to how far owners can go after an entity for their rights of publicity. If you look at, for instance, the Hurt Locker case, in that specific instance, the author had actually been embedded with the military and then wrote a piece for Playboy magazine which used the actual individual's name. Then turned around and wrote a screenplay that was about an individual in the military, and the argument being made in the Hurt Locker case is it made the individual look like he was in a negative light, like a bad father, and so on and so forth. But the reality is that it was separate from the actual story or the article that was written in Playboy. So it raises a lot of questions. And when the thing that Hurt Locker did not do is they did not sign over any type of life rights or releases with the individual.
okay, help us out here. What exactly are life rights? I mean, where's their role in this whole discussion?
Well, life rights are a contract between an individual and for instance, a production company that allows that production company to exploit or write a story based upon the life story of that individual. Now, there's a lot of questions as to exclusivity and freedom to fictionalize. That's one of the limitations that signing a life rights agreement can do, is it can limit the ability of the producer to fictionalize the story. The other thing is that a lot of the productions don't have the budgets to purchase the life rights, which is probably something similar to what happened in the Hurt Locker situation, where they started off with a much smaller budget and they didn't have the funds to purchase outright the life rights of the individual.
Okay. What about, I mean, do we have another potential plaintiff out here? I mean, let's assume for a second that the mayor was someone of some notoriety and had signed her life rights over to a major production company. And then this film comes out that touches on, I mean, could that production company sue? You mentioned exclusivity. I mean, does that somehow grant the production company the ability to sue the producer of our fictional movie for some violation of that agreement?
Well, if someone is suing you, that means you're doing something right. It's just a normal thing in our industry, unfortunately, that if you're successful, someone will sue. If you look at specifically Hurt Locker, it was ironic that the plaintiff filed the lawsuit the day after Oscar voting closed for that specific period. It was all strategic, and it was very much a timed thing.
Yeah, the publicity was that they waited until
Right.
the Oscars so that they could steal the spotlight from Hurt Locker, which was getting a lot of awards, and everybody knew that. If I can say a word about rights of publicity and maybe take a slightly different approach, and there really are two very different schools of thought. One generally comes from the artist's side, and the other generally comes from the producer's side, enabled by bastard defense lawyers like me. If the New York Times is writing a story about Ivan, they do not need Ivan's permission in order to write a full-length biography over the pages of the New York Times if he's newsworthy and there's something that they want to write about him. And it's true, and it does not invade his privacy by telling intimate things that aren't newsworthy about him. There is a long line of cases, and The Perfect Storm is one of them, that said that those same rights apply to theatrical productions, whether it's on a television medium or in a movie medium, that if it's a truthful story and it's about somebody who does something that's of public interest and newsworthy, there is a First Amendment protection to tell that story. And if I am brought in by Lynn in this hypothetical to help with the case, what I'm going to do is I'm going to walk into the producer's office, I'm going to put my feet up on his or her desk, because we're going to get real cozy and get to know each other pretty well, and I'm going to say, show me your file where you base this on truthful information about a matter of public interest, and at the end of the day, I think I can persuade the judge or jury that you had a legal right to do that. Now, that's my view, and that's been vindicated in a lot of the case law. But often it becomes a matter of risk aversion or risk tolerance or money, because people like me don't come cheap and don't work for free.
I've worked with him. I know this, just so you know.
Well, and the other problem is that in this scenario, you know, it doesn't sound like it was newsworthy. There's nothing to think. I mean, it sounds like it's a great storyline, and the producers love it, and this screenwriter, you know, did a great job, but chances are that there is no file, you know, on how these women getting together, you know, for lunch with funny hats. Now, maybe they were featured in a New York Times Magazine piece, you know, and that's where the producer got the story from. That's different. But you're right, it's going to be a risk assessment, because the first thing I'm going to ask the producer who's sitting in my office is, okay, where'd you get the story idea? Has this been published? Have our stations, if I'm working, you know, if I'm in my position, I'm going to ask, has anyone did a story on this? Has anyone in our news division portrayed this? You know, before our international or our studios publish it.
And that's why different studios have different production standards, different clearance procedures, different clearance packages. I was just looking at a form that a client developed the other day that has the producers and the writers sign off and warrant and represent that this is a complete work of fiction and not based on anybody I know, or this is based on a true story and here are my research materials, in order for the studio to be able to assess the risk and make decisions.
Well, and that's really quite perilous. I mean, our fact pattern is kind of easy on that point,
That's right.
in that you know walking in, this is based on real life events. I think it would be actually quite terrifying, not knowing where or what content may have gone into this script that comes in where you don't actually have knowledge. Because after all, at the end of the day, I mean, all writers base their writings on real life events.
On some type of experience, and that's why many times you also have in different parts of the world, the same writers coming up with very similar stories. And, you know, you may be faced with, is this an original piece or not? When, you know, clearly there's a very similar piece somewhere else.
And so you develop these, I'm sorry, go ahead.
Another important thing is that, you know, different types of content also require different type approaches. If, for instance, you take reality television and you were going to make a reality show out of this, those are the types of things that would normally be contracted out first. If you're entering with these ladies, for instance, and that they've never been famous or never published or never written, you can actually contract certain rights over to the production company, basically stating that you indemnify the production company from putting you in a bad light on the television show. That's one of the advantages that reality has had insofar as contracting. Although there are also certain limitations that have been hit with specifically locations, because you have a reality show, you have characters, they're contracted with the production company that they don't mind if you shed them in a bad light. However, if you're going to take them to a public place, you need a location release from that public place. And most likely, you will want that location to release you from anything, including allowing or permitting the place to be shown in a bad light. And that can be one of the limitations in reality television towards the releases.
And one of the biggest problems we see lately is that blurring of the lines between the reality TV and the fiction. And where do we draw the line of where is it really reality and where are we writing to it and really acting it out to the point that it is now, you know, scripted. And that is a very fine line, which with different standards, as Ivan said. On the reality show, we have individuals who are coming in and saying, you can film me, you can film everything that I do, and they are signing their life away. They want the fame. On a scripted show, you are going in, and a scenario like this, in which you are going in and you're writing about a group of women who have no interest and have not wanted to be in the public light. That standard is going to be very different, and the law is going to protect them because they have not put themselves out there. So when you start crossing that line and you want to make, and a lot of times producers say, but I want to make it look like it's reality, you know, and we don't want to burst that bubble of not making it look like it's real. Well, you have to be careful because you have to keep in mind that the law will always protect those individuals who we are putting into the public light rather than the ones that have put themselves in the public light. And I think that's an overall issue that we will start facing as an industry as we get into more and more different type of genres as the reality show genre keeps progressing.
Well, stepping back to scripted, I mean, all three of you are very, very accomplished lawyers. I don't know, you know, whether you have background in writing scripts, for example. How often do you actually get in there with your clients and say, look, you need to change this, this, or this in the script? Essentially, to some level or another, rewriting the thing. And, you know, when would there be a situation where you would counsel those sorts of actual script changes?
As a former journalist, I take a lot of pride in not changing scripts because I've been on the other side in terms of vetting, you know, news stories. And if I'm changing a news story significantly, then I'm not doing my job right. Because I believe in our role as a media lawyer, and Chuck can chime in on this, is the fact that we're supposed to make the piece better. We're not there to rewrite the piece for them. Now, we may ask 5 more questions, and they may rewrite the script themselves if it's an investigative piece and they haven't presented both sides of the story. And that's on the news side. So on the scripted side, I have had to go in and we have had to go change portions of the script. But that's been because we made a decision as a company that that's not the direction we wanted to go. And it was never, you know, I'm never going to write the script for them. I'm going to go back and say, listen, with your creativity, this is your piece. This is what we need to accomplish. This is the goal, and this is the direction. How can we take the piece that we are producing and move it in that direction without ruining the creativity? Because really, once we start, you know, infringing on the creativity is where we're not really doing our jobs, in my personal opinion.
Ivan, that said, like things like changing the names so they don't match, I mean, would that be something you would recommend in this to make it maybe a little more difficult to connect the dots that this is of and concerning, to use a legal phrase, the original?
Well, the interesting thing is you have to remember that we are not the only ones vetting the project as well. You have the insurance companies that you have to deal with as well. And the insurance companies have their own beliefs of what they think should or shouldn't be covered. So,
because we're requiring them to give us E&O of $5 million or $10 million, and they're going to want to make sure that, you know, it's a piece that's cleared.
Yeah, for a dramatic work like the hypothetical, if you're going to have the characters deviate from the literal truth of what went on in this situation, I would advise changing the scenario. I would make, if they were 30-something-year-old women, I'd make them 60-something-year-old men if it fits with the storyline, or I'd make them older women. If they wore funny hats, I'd have them wear funny brooches. I would get involved in the creative process to the extent that the talent would allow me, the producers, the writers would allow me to do that. I would advocate for changing the hypothetical, and I would also put inspired by a true story rather than based on a true story.
Okay, so there's a difference there.
I would change the
There's a very
credit.
big difference.
Okay,
I would change
what
the
is that
credit to
difference?
say that.
Just out of curiosity, what's the difference between based on and inspired by?
The difference is courts have said one means that it's literally true, and the other means, and that you clearly meant these people, and the other recognizes that it was the point of departure for your story from these people. I might even throw in some pepper the script with things to be able to say to the judge later, and my job obviously is to help set you up for what you will argue later in court if the roof caves in on your production. But there was a Law and Order recently based on the events of Tiger Woods in front of his house with his wife, and they had a golfer in there, and the golfer made a reference to Tiger Woods' incident. Gee, I thought this only happened to Tiger Woods. Well, if Tiger Woods were to sue, there's an element in the script you can say to the judge, not only weren't we trying to imitate Tiger, we told everybody it wasn't Tiger Woods. And therefore, when the character went on to commit a murder, we weren't talking about Tiger Woods in the script. So there are changes that I would advocate to try and steer them in the right path.
So Chuck, let's assume for a second that our swashbuckling producer refused to take any of the advice he was provided in terms of the creation of this magnum opus. And so this has now gone to litigation. And you've got 4 causes of action that are filed. You've got your typical privacy claim brought by the husband, false light, defamation. You've got the 2 ladies bringing defamation, false light, invasion of privacy, disclosure of private facts.
Sure.
And then you have the mayor who's saying this is a misappropriation of likeness for commercial gain. Do you win? Or are you calling the insurance company saying post limits on reserves?
Well, I would certainly advocate for healthy reserves, if for nothing else, for legal fees.
Very good. Happy to put your kids through college.
Exactly, and you are. But most of the fact pattern actually, I think you come out okay. There are a couple that are troubling on them. I think that there's a character in there who's an alcoholic and portrayed as an alcoholic. If that woman sues for defamation, she's going to lose because there's no falsity in saying that she's an alcoholic. I believe the fact pattern also says that it is well known and well publicized that she's an alcoholic. So the illness of alcoholism is not a private fact, therefore she would not prevail in an invasion of privacy lawsuit. The philandering husband we talked about earlier, yes, in most states it's defamatory, even in Nevada probably. But for that one, I would put on my creative bastard defense lawyer hat, and I would want to talk to everybody who knows him. I would want to talk to everywhere he goes. I'd want to know where he goes to dinner.
That's right.
I'd subpoena his credit card bills, and I'd want to see if the future second Mrs. Trophy wife and he have been out in public together, and if they have registered at hotels together and whatnot. And I would want to put on a case, develop a case that this wasn't a private fact about him, and that if it's truthful, there is no defamation claim there as well. I think there was one other element in there as I was reading it, a woman with a psychiatric history.
She had a psychiatric history. It was not known by the author at the time the script was created, but discovered later.
Okay. It's truthful, so if it's truthfully portrayed, there is no defamation claim there. If it is something that she has kept between her and her doctor or her and her husband, and it is a private and intimate fact, the writer's innocence in happening to stumble on that probably wouldn't protect them. They have exposed somebody's private and intimate health issue in a public way that wasn't public before, so that would be a troublesome issue as well. To get to the overlying premise, 4 women going out and committing madness and mayhem against a man, there's reality, docudrama, and then there is 9 to 5, okay? If it's absurd, campy, Lily Tomlin, Dolly Parton, and Jane Fonda, I would be less concerned if that's the motif, if that's the genre that we're defending here, because I don't think anybody is going to believe that that really portrays Julie and the other women. If we're talking about, edgy, hard-edge camera with really scene-setting music for each scene, and it looks more like it's reality and it says based on a real story, that would give me more concern because it's more likely people would think that these women are going out and taking body parts off of this man's husband.
But something that I'd like to bring up is, at this point, we've spent hundreds of thousands of dollars in attorney's fees.
Right.
For this production.
Hopefully you're over your deductible and he spent the hundreds.
That's true. Hopefully it was a third-party production company and they're the ones paying for it rather than ourselves. But if it is our own production company, that's something to take into account. Ultimately, I think everyone on this panel would agree that this is a defendable position. And then we would likely win because, we would all subpoena the husband, all their records, and probably bring out every person that he knows and ask him if it's hurt his reputation for him to, have an alleged affair. And chances are, no one's going to say that. So the question is, though, from an in-house perspective, okay, how much has it cost us now in legal fees when certain minor changes to the creative, something that is not substantive, that would not have affected in any way the value of the production, could we have made some minor changes or even contracted out with, as Ivan mentioned, for some nominal money, because these people are not public figures, are not well known, they're private individuals, contracted out the rights, and probably have minimized the risk significantly, both for, even if it is a third-party production, for the broadcaster, or even producing a piece that would probably be a lot less risky and get you more return on the investment, ultimately. So.
Just another point that I wanted to mention as well, as far as the right to publicity, and another danger that exists is the fact that I think 18 states have passed stringent rights of publicity laws nowadays. A lot of them have statutory attorney's fees. So the attorney's fees of the losing party or the winning party is also a consideration to
as well as whether they're alive. I mean, in many jurisdictions now, their rights of publicity statutes, as I understand them, don't end at death.
California and Washington State have been very proactive.
There's an ongoing case with a Jimi Hendrix.
In Washington.
Right.
Right.
Yeah. I mean, some last as long as 40 years.
Yeah. So, I mean, even
Indiana is 100 years after death.
That's right. Indiana is most extreme. So, I mean, while you may be safe from a death, and we haven't talked about this, but typically you can't defame the dead. When you're talking about a misappropriation of name or likeness or a privacy claim, then the fact that the person's dead may not save you, as the saying might go. We wanted to reserve a goodly amount of time for questions and answers. So I'd like to take this time to throw it out to the audience to see if you have any questions for this great panel. Don't be shy.
Okay, that would have taken a while. Larry Epstein from Drexel University in Philadelphia. In the case of the perfect storm, so maybe this is a question for Chuck, you didn't mention anything about discussions about possible settlement. And I'm wondering, was there too much money involved, or was it a matter of setting a precedent, or what could have, or at least hypothetically, if you don't want to reveal details, goes into the question of whether a studio or a producer settles with an individual or a family? Thank you.
I'll tell you generally that Warner Brothers is a very tough client, tough in a good way. They stood behind the production. They made a lot of clients make conscious decisions. As I said, there are two schools of thought here, and Warner Brothers at the time and now generally is of the mind that when they're doing nonfiction, they don't need releases. The law protects them, and that they will vindicate that when they have to. We felt very strongly that the dead plaintiffs had no business being in court through their personal representatives. The wife of the John C. Reilly character and the George Clooney character had nothing wrong said about them, and their rights weren't invaded. And so the client decided to move forward, and knock wood, got a good result out of it.
What about something that is unintentional? I mean, you do something, as far as you're concerned, it is totally a work of fiction, and then somebody you've never heard of, out of the blue, says, oh my God, you are doing my life. This may be an urban myth, but I heard that this happened with the cartoon strip Dilbert, that several companies sued saying, you know, you have, you know, portrayed my company in a bad light. And as I say, that may be an urban myth, but I know that there have been instances where this type of thing has happened. A person, you know, who thinks they're creating complete work of fiction suddenly is slapped with a lawsuit, you know, for, you know, defamation, misappropriation, whatever, because they're claiming, oh no, this isn't fictional, you know, you've plagiarized my life.
It actually happens all the time. That's why every studio has very stringent, or should have very stringent, requirements as to how we obtain scripts from, you know, especially from writers that are fairly unknown or not used to regularly working or on staff. Because what can happen is many times you can receive a script, no one on your staff may have read it, none of the decision makers, no one of significance even saw it. It may be sitting in the mailroom, but your company received it. And they have proof of having sent it to your company. Yet no one, you know, and then you went and created a very similar piece, and then you're sued for a copyright infringement, for example, or idea theft. So that's why you need to have an intake procedure that protects you. And you can't just accept scripts from people you don't know or that aren't represented by an agent, or without a process being in place to protect you as a production company, to prevent situations like that.
The only impediment to filing a lawsuit is the creativity of an attorney. You look at, recently there was a Pixar Disney lawsuit where they sued based upon the Cars animated film, because there was a race car driver that drove a red car with the number 95 on it. Disney and Pixar ended up winning that case, but it just goes to show you that however creative the attorney is filing the lawsuit, it's a reality.
Just make sure you have a good legal budget, basically, is what you're telling us.
Always. Put in one note, and this is more on the journalism side of it, comes up more often. If it's a public official or a public figure that you have accidentally libeled, then you're going to be okay at the end of the day, because it's harder for them under actual malice standard. They have to prove that you knew it was false or intended it.
However, that's only under defamation, not under rights of publicity.
That would be
because
correct.
You don't have the additional burden.
Right. Well, and there are, you know, when you're talking about a specific fact pattern, that's hard to research, but there are certainly script clearance companies that research names, and I mean, what's the role of them in the process?
They support the production company. I mean, we go through title clearance companies, and we do copyright clearance, for example, to make sure we don't use names, and we use the same type of companies to make sure that we're not using names. I mean, I remember a lawsuit a couple years ago where it was for a jingle of, I think it was Corona beer, and they just happened to pick a name. The agency, you know, that created the advertisement happened to pick a name. It's actually an insurance case. And what happened was they just happened to pick a plaintiff's lawyer's name. Wrong person whose name's to
Always
pick.
bad.
You know, he had nothing to lose in filing a lawsuit, and we had to settle because it really represented and made the people in the community in which he practiced law make it seem as if it was him, because he had an unusual name and they portrayed him in a false light. So, I mean, you have to clear names, you have to clear titles. It's an essential part, because if not, you may think that you're doing something very creative and it may be used by someone else.
The best advice is talk to Chuck.
That's right.
Happy to help.
Any other questions? Yes, if you could step up to the mic, please.
My name is Camila Wilches. I work in the Business Affairs Department of Telemundo. I know Lynn quite well. So this is a question to any of you who has seen the Social Network movie. Because I'm wondering, where is the line between the truthful information and newsworthy and the privacy rights of Mark Zuckerberg, the way he's depicted in the movie?
I know a little bit about the process that they went about making that movie. They made a deliberate decision not to obtain clearance, and it was very heavily based on the litigation and all of that on public records and on Zuckerberg's own writings and all of that. And so the movie was vetted by lawyers for the company and for insurance, but it was done with a very good record to go by. Now, they made up certain things, tones of voice. There's a great scene where Zuckerberg is giving a deposition in the case, and he's looking off and, not paying attention. And the lawyer says, "Excuse me, are you paying attention to me?" And he says, "Yes." And then he proceeds to give him a brilliant, up your you-know-what answer. And he says, "Did I answer your condescending question, counsel?" Now, that came out of a transcript. Did the tone of voice and all of that carry exactly that way? Maybe, maybe not. I don't know Zuckerberg and how he sounds. But the implication that he was being snotty, who cares? I mean, it was very clear from the transcript itself. So in that particular movie, they made a decision and they had a good record to go by.
Well, that raises a good question. I mean, when would you not get releases? I mean, is it by getting a release or trying to get a release that's refused? Are you admitting that you should have gotten a release to begin with? Or, I mean, when would you not at least take a run at getting someone's authorization to use their name or likeness or story, whatever the case may be?
I think it goes by, is this person newsworthy or not? If the person is newsworthy and we're going to have enough of a record to stand by, then you run the risk that if you ask for a release, it will likely not be given to you. And once they refuse the release, then you have that record. So I take the position, just like Chuck, as I think most of the three major networks do, that we will not need releases in situations that are newsworthy, in which we have enough of a record, where they are public individuals or semi-public facts or public events. And we will continue based on First Amendment rights and our freedoms of creativity to be able to create situations like that. If not, our industry will go to the point where we need releases for everything, and we will be paying more in rights than anything else. So I think as a general consensus as the industry, we do take the position that we do not need releases if it is based on public events and there is enough of a record. Now, if we go back to our hypothetical, it depends if these people are public figures or are they private figures, and what are we doing with them?
Any other questions? No? Well, one thing, are we seeing a rise in privacy cases now? I mean, I think through the good work of people on the panel and others, defamation cases seem to be sort of fading a bit.
They have.
I mean, are we seeing that sort of being translated over to privacy and those sorts of claims, or are we seeing any trends in that regard?
I think we're seeing more and more lawsuits in terms of internet privacy and in those types of areas, and whether we are infringing, especially with as much information out there in social media and people grabbing from social media to put into other areas. So I think there is, I think the traditional defamation, luckily there is so much good law to help producers that we have not seen historic defamation litigation in several years to the level that we did 10, 15, 20 years ago.
Okay. Is that Ivan? Same?
Well, I think with the advancements in technology, it's affected tremendously in a couple of different ways. Number one, it's much more tempting to take ideas, and number two, it's much more easier to get caught after you take ideas. I mean, that what it has done to the industry has increased. And then the fact that the publicity cases, you had the first one was in '77 that made it to the Supreme Court, Zucchini, which was an individual that was shot out of a cannon, and a television news channel filmed it and then put it on the news, and he sued stating that they stole his act. And basically, on that case, that has kind of opened the door into the 80s. You had Woody Allen suing over someone taking his image. You had Bette Midler over someone taking the voice. You have little nuances and things that are constantly and continually being tested by the courts, and it's just fascinating to watch.
And I think you also have the development of new genres. I mean, look at The Simpsons and different, like the Family Guy. I mean, Carol Burnett suing over using her image in Family Guy. You know, and it was her image, you know, sweeping the floor that used to come out in the old Carol Burnett shows, and it was her in, you know, cleaning a porn shop, and she sued because she said that it was portraying them in a bad light, because she would not want to be associated as, you know, being associated with a porn shop. So I think there has been a different development in the type of television that we see. Reality TV has grown significantly. So I think the difference in technology and the difference in the types of genres are creating new litigation more in the realm of right to privacy than in the traditional realm of what we used to see in defamation.
Okay. As Lynn mentioned, also video games. You have Gwen Stefani sued Activision over the character within the animation that did certain acts that she wasn't happy about. It's just continually evolving.
Yeah. Okay. Well, on the no doubt note, I think we've reached the end of our time. Thank you very much to all the panelists for attending.
Thank you.
And thank you.